Okay, good evening. Welcome to the 1873 FM and TV show. Today we are looking at the Zimbabwe I want, alternatively the Zimbabwe I don't want. What kind of Zimbabwe do you want to see? I'm joined on this panel by Miriam Mutizwa all the way from Ontario, Canada. Good afternoon.
Afternoon, Mr. And hi.
I'm also joined by Dr. Shumba. Good evening.
Good evening, Mr. Mawere, and good afternoon, Miriam.
Good afternoon. Good to see you.
Indeed, it's good. It's been a long time.
My apologies, I've got background feedback.
What's that? They're running around like horses?
Huh? Okay, can you hear us now?
I can hear you, Mr. M, but Doc is in and out.
Okay. All right. The topic is the Zimbabwe I don't want to see. And posted on the screen is a judgment that was handed down yesterday in Zimbabwe. A Valentine's gift. This is the Minister of Justice, Legal and Parliamentary Affairs versus Hwange Colliery Company Limited. Perhaps we can start with Dr. Shumba. Have you been able to go through the judgment and
I have cited. I have seen the judgment, and I've looked at aspects of it, and should have conclusively analyzed it by Tuesday. I would need to benchmark it and check the various references and cases that the judge is referring to.
And Miriam, have you had a chance to go through it? Hello?
Hello?
Yeah, have you had a chance to have you had a chance to go through the judgment? Okay, maybe we can just proceed. The Zimbabwe I don't want to see. Is there anything in this judgment that...
Let me try another device. This is cutting in. But you carry on.
We can hear you now. We can hear you now.
Right. Go ahead.
So, Dr. Shumba, perhaps you can let's start with this construction where this matter involves a minister who issued a reconstruction order in relation to Hwange Colliery, then approached the court as required by the law to confirm this extrajudicial order. And in a constitutional state, perhaps we can start there. What kind of Zimbabwe do you want to see? A constitutional state or an unconstitutional state?
Thank you very much, Mr. Mawere. It's important for our viewers and listeners uh, to get a slight background. I think someone has got some serious background sound there.
I think it's Miriam. Okay, go ahead.
To give some background to the issue. What's important is for the audience to get some background as to what transpired and what led to this outcome. This outcome by the High Court. Pertinent is that the minister issued a reconstruction order against the Hwange Colliery Company Limited and appointed an administrator in terms of the Reconstruction Act. We shall talk about the Reconstruction Act standing separate to the process. The Act requires that the order issued by the minister be confirmed by the court. And it is that confirmation that was being contested in the court of law. Had it been confirmed, it would have given operation to the plunder that the minister and his cronies intend to have to visit the assets of Hwange Colliery Company. However, it's important also to examine the nexus of this problem in Zimbabwe. The Reconstruction Act has been in operation for over 15 years, and it has carried with it 2 other victims, and Hwange Colliery being the 3rd such victim. This act should not have seen the light of day in a constitutional state such as Zimbabwe should have been, because of the blatant irregularities that are in the act, the contraventions that are in the act, and the broader violations of the Constitution and contradictions that arise when compared with the provisions of the Companies Act and the Insolvency Act. So we have here what I term a cowboy kind of act, which the minister was attempting to get the court of law to confirm the order that he gave. Important to note is that in terms of the Constitution of Zimbabwe, only a court of law can issue an order. No individual, no other body can issue an order of any sort against anyone unless it is a court of law. In this instance, the Reconstruction Act provides that the minister on his own can issue an order to reconstruct any company that he deems indebted to the state in terms of the Reconstruction Act. Now, it's also important that we find out that the state intends to identify itself and place itself in court in what form. Because in terms of the Constitution of Zimbabwe, in terms of the Reconstruction Act, and any other act of law, we do not have a body or a body corporate or an entity or a subsidiary of an entity that is called the state. I defined earlier that the state of Zimbabwe is everything that is within the borders of Zimbabwe, including its citizenry. I also explained that the state of Zimbabwe also includes those things that are outside of Zimbabwe that represent the interest of Zimbabwe. In simpler terms, every citizen of Zimbabwe is a member of the state, compounds and aggregates to what is referred to as state. And therefore, you cannot telephone the state, you cannot visit the state, you cannot find the state, address the state, or go to the state, or locate where the state is positioned, because the collective citizenry and everything that is Zimbabwe is what is in effect referred to as the state. So the very fundamentals of this State Indebtedness Act fails. We've got a terrible sound coming from somewhere.
Okay, I think it was me typing. Okay, go ahead.
Yeah. So that is the other thing. The second thing is...
So maybe let me get it to a pedestrian level for the next 5 minutes. Just pretend you are a pedestrian. I know you are not. Here we are.
We don't know who was before the judge in court, because there is nothing called the state that was before.
Yeah, you have been talking about constitutionalism, the rule of, and we want to use the facts of this matter to test whether the climate in Zimbabwe is conducive for the operation of the rule of law. Here we have an act of parliament that is now 15 years old. This act of parliament permits a member of the executive branch of government to issue an order of a limiting nature, an order that has the effect of divesting and or depriving a citizen of their rights in relation to a company. This idea, Dr. Shumba, a member of the executive being clothed with such power to issue an order, as you have stated before, is inherently unconstitutional. Is that correct? Hello? Hello? We were talking about a constitutional dispensation that allows a minister or a member of the executive branch of government to issue an order that has the effect of limiting the rights of a citizen in relation to something, whether that power conferred on the minister is constitutional or not. Dr. Shumba. So we seem to have a network problem with Dr. Shumba. If you are listening out there, if you are watching out there, is it the Zimbabwe you want, in which a minister as the executive branch of government can be clothed with the power to limit the rights inherent in any citizen? Dr. Shumba, are you back?
I'm back. This Wi-Fi is failing us.
Okay. So that's the question is simple. Would you want to live in a country where a minister, being a member of the executive, is given a discretion in terms of law to issue an order whose effect is to limit the rights of citizens?
Well, it is first unconstitutional for such rights to exist in the first place. We would have to introspect and look at the previous judgments that were issued, more especially by the Constitutional Court, who failed in their duty to recognize the superiority of the Constitution. But it's also important to put Parliament to task. Parliament must explain how such an act passed through the 4 stages. 1, the Parliamentary Legal Committee, which whose task is to ensure the constitutionality of a bill. And secondly, the 3 readings in the lower house, which we call the National Assembly, and the readings in the Senate. That alone will show you that the process that was undertaken was highly compromised, and of course, the authors of this act, including one who was leader of the House at the time, the Minister of Justice, Minister Chinamasa, who was the leader of the House in Parliament, ensured that Parliament would ascend to the partisan wish of the authors and compromise the nation state of Zimbabwe. Such criminality
we're
is
joined
important.
I think we are joined by Mike. Is that Mike there?
Yeah, that's me. I'm here. Yeah, can you hear me?
How are you?
I'm well. I'm well. I'm just listening in. How are you
Are
there?
you
How are you, Dr.
following?
Shinoda? How are you doing?
I'm doing fine, Mike. I can't see you, but I'm assuming you're a handsome man from the sound of your voice.
Don't say that. Yes.
you,
No, we are
you can
blessed. That's the
imagine
most important thing.
while we are blessed, we have a diabolical, callous government that is presiding over the nation of Zimbabwe in terms of expropriating assets of private and public entities for the purposes of enriching the few that are in power and are able to manipulate all processes, including court processes and other constitutional processes for personal benefit. So basically, it's important that, as I stated earlier, that only in terms of the Constitution of Zimbabwe, only a court of law can issue an order and not the Minister of Justice. Secondly,
Okay. And
the,
Mike, are
the,
you following?
I am.
the
I am. Yes,
reconstruction,
I'm listening. I'm
the
Okay.
listening.
So maybe,
reconstruction, the Reconstruction Act has no space, purpose, or need to exist, because what it seeks to address is already covered by the Companies Act and the Insolvency Act. So the role of the Reconstruction Act is clearly one that was ill-conceived, with an agenda other than one that would have enriched the corporate governance of Zimbabwe. Thirdly,
okay.
the powers that once a minister places an order of reconstruction on an entity, the powers that it gives the administrator that he singularly appoints are unheard of and clearly driven by diabolical intents, because the administrator elbows out a board of directors of that entity and dislocates that entity from its shareholders. The
So
administrator also takes over the rights of creditors. In other words, creditors have no rights to monies that they are owed, because the Reconstruction Act only gives them remedy at the pleasure of the administrator and at amounts that the administrator will singularly deem fit and appropriate. It also negates the rights of employees and gives power to the administrator to basically asset strip those entities and form extra structures without being answerable to anybody, and come up with a net summary of a reconstructed company, which may be handed over to its original owners or which may be denied, as in the case of SMM. You are going to see a litany of these irregularities being well amplified on the SMM case and on the Air Zimbabwe case, where while Air Zimbabwe is under reconstruction, they appoint Chinamasa as chairman of a reconstructed company, when in terms of the Reconstruction Act, there is no board, only to wake up and they've created a parallel entity to take over the services of Air Zimbabwe, while negating the first right of claims of creditors to their monies in terms of the Companies Act. Now, when a company is being instituted, a company can only be instituted and established in terms of the Companies Act. The Reconstruction Act does not establish a company. Now, you cannot give birth to something and then you are wished away, is what the Reconstruction Act seeks to do if allowed to subsist. Therefore, Judge Mangota shouldn't have entertained the minister's application to him to confirm an order of reconstructing Hwange Colliery because there was no legal standing upon which the minister would have confirmed that order or issued that order in the first place, because he is not a court of law and he could not have issued an order that he now sought to be confirmed by the courts. Interestingly, in terms of the Reconstruction Act, the duty of the High Court is not to preside over the minister's application for confirmation.
Okay.
The duty of the court is not to preside over the minister's application for confirmation because there is no provision for that. The Reconstruction Act says the court shall confirm. In other words, Judge Mangota simply should have stamped the minister's application and granted it in terms of the Reconstruction Act. By questioning the minister about the legality of the process he had undertaken, Judge Mangota should have gone the full stretch of the law to question the very locus that brings the minister to court to seek a confirmation of an order that wasn't granted by a court of law. That would have located the tenets of the Reconstruction Act and its contraventions to the Constitution of Zimbabwe. Those are the broader issues that I thought I could set out to allow our viewers to follow.
Okay, we have one such viewer. Mike, have you followed what Dr. Shumba has been saying?
Yes, I have indeed. Yes.
Okay, so if you were to summarize what he has said, what would be your summary?
My summary from his narrative. From his narrative, he's saying, we've got ministers who, a certain individual who's overruled, and taken issues to their own hand to award something that is supposed to be done through a board in Zimbabwe in order to benefit those that are interested parties around him, basically. Is that right?
So if we take the theme of tonight, the Zimbabwe I don't want to be part of. This Zimbabwe is what Dr. Shumba was referring to. That in the United Kingdom, there is the judiciary, there is the legislature, and there is the executive led by Prime Minister Johnson.
Yes.
And in this instant case, a law exists in Zimbabwe and operates in Zimbabwe that permits a minister in the cabinet that has just been appointed by Prime Minister Johnson to issue an order. You know what an order is, Mike?
Yes.
Okay, perhaps you can tell our listeners what is an order.
An order, I think, just from someone who's to make it simple, an order is something that is carried forward. It's an act of action. So once you're carrying an order, it means you can execute anything because it gives you power to do that.
Okay, Dr. Shumba, would you want to
Indeed,
explain?
Mike is correct. An order is a directive, a legal directive by a court of law permitting a certain process to be legally undertaken, whether that in respect of a marriage, it could be one that dissolves a marriage. It could be an order to put a company in insolvency. It could be an order to declare
So
an election.
it's a
An election,
decision.
it could be an order to declare an election irregular. So it's basically a decision of court that has to be abided to, and it gives direction on what it intends to achieve.
So
That's
if
it.
I order that you must serve 3 months in prison, it means that it's a decision by that competent authority to limit your rights.
Indeed.
It is by that
That
order.
is,
It is by that order that allows the individual who's awarding whatever they're awarding, gives them that authority to award whatever they award. That 3 months has been awarded because this individual holds the authority to do that via an order.
No,
yes.
it will be punishment or a decision. Either way, we go to court to seek an order.
Yes.
We don't go to government, the executive, to seek an order.
Indeed. It's provided for in the Constitution that only a court of law can issue orders. Now,
so okay, do you understand?
We now have the Reconstruction Act that says a minister can issue orders. So clearly the Reconstruction Act, on that single point, it's in violation of the Constitution of Zimbabwe. And therefore, on that basis, it's a voidable piece of legislation.
Okay. So, Mike, do you understand why it is important to link it to the Zimbabwe you want? You can tell from Dr. Shumba's analysis that he is opposed to anything offends the Constitution. The Constitution,
Yes.
Only the court can issue orders of a limiting nature. Yet, a law exists and is being enforced under the new dispensation that permits the opposite.
See, here is the problem. The Zimbabwe we want, I'm sure the Zimbabwe Dr. Shumba is articulating right now. There is no one else within that parliament who can question that. That is the sad side of things. Because what is right should be right. Whether those who are in government now like it or not. Law is law.
But Mike,
Yeah?
did you know that a law of this nature exists?
I've heard of it, that but not in briefing the way Dr. Shumba has put it across.
So this is your first time to learn.
Yes.
So let's sing Amazing Grace.
We have already sang the Amazing Grace.
Was blind, but now I see.
Was blind, but now I see.
Yeah, but don't expect
But it's important. It's important, Mr. Mawere, if you may let me come in.
Yeah.
Mike raises a very important question.
Yeah.
Indeed, for this act to have become law, it had to go through the legislature
Parliament.
and
Yes.
Parliament, and of course, the first port of call is the Parliamentary Legal Committee, which has always been chaired by ZANU-PF to ensure that a partisan position is upheld. That and the very fact that ZANU-PF has held the majority in the houses, the MPs would be whipped into line along party lines and vote for an illegality. Your point is, do we have the caliber of MPs who could refuse to do something illegal? I not under the current ZANU-PF structure. They are all very partisan. They all suck up to their master. We have MPs that were there before.
What if Dr. Shumba? What if they don't know the tenets?
That's a very good question. That is a very Dr. Shumba. You really need to take that what Mr. Mawere has just said seriously. Also on that point,
it's
are these
important,
people
and
that you
I
think?
agree.
Yes,
I agree with you because I was in Parliament, and of course there was daylight between a number of us there at the time I was a legislator, and that also goes in terms of our electoral act, in that sometimes you elect people that are not cut for the job purely because they are qualify in one way or the other. So normally it's not about qualitativeness all the time. Sometimes it's about quantity. And these are some of the porous issues that then go through where voters don't know that the person they're electing is going to be introspecting on critical issues. And they will vote him in because he's bought them beer, he's bought them maize, he's a thug, and has been able to threaten people or bribe people. So we do get a lot of these leakages of voidness in terms of intellectual capacity. But be that as it may, it is up to the individual. It is up to the individual MP to decide what to do. Can you hold on, please?
All right. And
you see,
Mike, are you learning something?
every day is a learning day, Mr. Mawere. Every day we learn something, and the things that we learn will always interlink somewhere.
The thing that I learned.
I've learned. All right. Okay, I'll bring it back. The things that I'm learning every day always
Hello?
link up. Always, yeah, it's back. There's always something new I'm learning every day. Even with the political circles in Zimbabwe,
on this platform tonight.
Yes.
Is there anything? Are you learning tonight?
Yes, I'm learning. Yes, and it's good. It's good for us to, because a mind that is not open to learning, doesn't grow in terms of wisdom.
Okay, so let's look at what kind of Zimbabwe we want to see. And Mike, assume that parliamentarians are human beings like you, and you are singing Amazing Grace.
Yes.
But we have not brought some of these MPs to truly understand the implications of this law and the consequences of this judgment. So I ask Dr. Shumba, when you look at this judgment, at the end of it, what is the order that the judge has given?
Very important to ask, yes.
What is
Yeah,
his final
kindly read it to us verbatim for the benefit of our viewers, Mr. Mawere.
All right, so let's
Yeah.
go to the end. Yeah, this is his signature. He says,
Okay, let's see. Somebody.
the minister, in my considered view, failed to prove his case on a balance of probabilities. The application which he filed cannot therefore stand. It is accordingly dismissed with costs.
Let's go a bit more on the top. That was the final say. Yeah, I wanted to build to the building to the judgment.
No, the law has no provision for judge dismissing. Did you know that, Dr. Shumba?
Mr. Mawere. Yes, I mentioned it earlier, Mr. Mawere. I think the question Mike is asking is the learned judge is ruled that the minister, in his considered view, failed to prove his case. Indeed, the minister, I would like to go on if you allow me. Indeed,
Okay.
the minister failed to prove his case in his considered view. The other view that the judge has failed to recognize is that in terms of the Reconstruction Act, the judge is not supposed to have a considered view. The judge is simply supposed to confirm the order.
Mike, do you get that point?
That is what is provided for in the Reconstruction Act, that the court shall confirm.
The minister has nothing to prove.
But you see, the thing is, what we have to understand is, I think from what I've understood now, is judges do not make law. So the judge did not make this law, and the judges actually ruled that the minister could not prove anything under this law. So we have to also respect the judiciary itself in the fact that all they are doing is applying the law that has been given through the legislation, because with democracy, I see majority of the time is democracy, we want to speak democracy and interpret it in our own way.
No.
And
Now
this is, I think, we have.
You are compounding, Mike. We are talking to you.
Okay.
Dr. Shumba was
Sometimes.
Mr. Mawere, I think I understand Mike very well. And Mike is very right that the judge did not make the Reconstruction Act, and he's supposed to rule in terms of it. Yeah, I agree with you. But even on the basis of that act, his ruling is wrong, it's objectionable, and on appeal, it will fail because all that the act requires of him is a confirmation.
That's right.
Now,
you're very right. But now, who is the right person?
Let's go to Mike.
I wanted to go back, Mr. Mawere, before we leave this particular point, and say to Mike, and say to Mike, you are right that we've got to respect the judges, but here is the issue that the court should have looked at. The minute the minister filed his papers, the judge should have looked at his papers, whether his papers were legally before him. And the judge must know and ought to know that the supreme law of the land is the Constitution of Zimbabwe and not the Reconstruction Act. And therefore, the judge ought to know that a minister cannot give an order. And if the minister cannot give an order in terms of the constitution of Zimbabwe, and that the preserve of that are properly constituted, a properly constituted court, the judge should not have entertained this matter and should have dismissed it for want of constitutionality.
But how has the government, how has the parliament of Zimbabwe and the government of Zimbabwe tie in this law to the constitution? Have they yet, in what line were they amending through the constitution? Have they not lined it up with our constitution for it to be awarded as an order?
No, they have not. I was in parliament, and it is this act that caused me to be fired from parliament, because I raised the issue of the constitutionality of this reconstruction order and the expropriation and thievery that was taking place by the cronies that set up this particular act. And so I am saying that whether or not we have an illegal
Hello? Hello?
Hello?
There.
I think he seems to have gone. Okay, so have you learned something
It
further,
is muted, I think.
Have you learned something further?
Hello?
Mike,
Mr. Mawere?
have you learned something further?
Hello, Mike. I was saying the court of law is able to strike down this act. Where the judiciary is a court is negating its responsibility to act constitutionally.
Okay. I do hear your point, and I do, it's a valid point, because it is not standing alongside our constitution, right? And I do appreciate that. So from where it stands right now, where further can we take this matter in order for it to be resolved? Because it is not meant that, because if he is given that judgment, and that judgment can be challenged, because he's applied the law, but it's not applied the constitution. So who else can we take this matter to in order for it to be heard?
Obviously, this matter will be taken on appeal to the Supreme Court. However, there are other judgments of the Constitutional Court that were issued by the Constitutional Court, where it turned a blind eye on the national constitution and tried to appease the authors of this act, and became an extension of the captured process. This is what I've stated, that our judiciary is captured, and it sings for its supper depending on who it wants to appease. You will find that in the whole world, outside of a war zone, you will not find an act of this nature in existence in any civilized society, because its job is to expropriate and legally steal from owners of capital and negate every manner and shape of constitutional and corporate governance processes. I raised this issue in Parliament. I want to mention this. I raised this issue in Parliament. I'm on record to have raised this in the full House and at committee level, because I chaired the Mines and Energy Portfolio Committee of Parliament. And it is for this reason, for raising those issues, that I was fired from Parliament. You must remember
I do
that
remember that.
I was in parliament on a ZANU-PF ticket, but I was never partisan. I dealt with issues in the most legal and professional manner. I was the only ZANU-PF legislature at the time who also voted against the first constitutional amendment, because it was
I know.
clearly one meant to capture the what? The judiciary. So parliamentarians have got powers of exercising their right professionally, constitutionally, and to serve the people that elected them, and not to serve a partisan cause.
But the democracy, if in a democracy, it does not mean that we have to award or write everything in favorable of the opposition, does it? Or in favorable of other people that see it differently. Because what we have to say to ourselves as a people is to educate the people that, when you vote, they have to vote right. Because
Yes,
like you said,
I
everything is
agree.
done on the partisans. Yeah, because if you take for example what has just happened in America, with the impeachment, with the lower house and the Democrats and the Republicans, they could not even entertain what Trump had done, and they had the law to support them with that, despite all the leading evidence to what has gone on. But they could apply law to dismiss the case, and it is it is standing and it stood. So it is within Zimbabwe itself and those around who can interpret things to this level of thought and the way you've articulated it, because you know it very well. Unless yourself again rise up to take this further, no one else will come in and do that, because at the moment no one has challenged it. There's a parliament sitting right now in Zimbabwe. Is that not right? Hello?
Yes, there is. We have a
Yes,
parliament in
there
Zimbabwe.
is. Has anyone? There is a parliament, right? Whether we say we like them or not, but they were elected by the people of Zimbabwe.
Mhm.
But how then do they go on and challenge things that they don't understand and cannot even articulate? That is the problem.
Yeah,
Because when
we've got a lot of parliamentary support services, organizations that bring scrutiny on the various acts. We've got people like the Transparency International. We've got people like the Environmental Lawyers Association. These all try to enrich parliamentary processes. What is important is the individual willpower of each legislature to stand by the truth and by the constitution which they took oath on, and to ensure the subsistence of that. Our problem is that the majority party negates its constitutional obligations, and it looks more at the benefits of the cronies that support it in order to move forward. Now, this law is very offensive in that it was enacted as a means of punishing certain people and expropriate assets of private individuals and public entities.
I'm going to ask you
For
this question, Dr. I'm going to ask, sorry to interject. You know, um, are you saying this law is not benefiting even the minor in terms of in relation to what you've articulated right now, the opposition
no,
that
it
is sitting
doesn't.
in the parliament tonight?
No, it doesn't,
Are you
because
saying if they
we we already have the Companies Act and the Insolvency Act. What this act seeks to do is already covered in those acts. There's nothing magical about what it is bringing. We've got a
okay,
law that says when you are owed money, you go to court, and the court rules on who is indebted to who. It gives an order. So
are
why
we
should
saying
this Why should this
Are we
law
saying,
come and say state indebtedness? What is the state? It doesn't even define what is the state, because a state is not an entity, and a state never
are
lends
we
to anybody.
are we saying that in Parliament right now, there is no members of Parliament or people who sit in the Congress from the opposition side who can act, who are not affected by this law and cannot see this law in any shape or form?
Most of them do see it, but it doesn't serve their party.
You're breaking away. Dr.
Hello?
Shumba, are you there?
So,
Hello?
since it doesn't serve their partisan interest to pursue it, I don't no opposition legislator is energized to pursue it.
So as we come to the end of the show, I was hoping, Mike, you would sing Amazing Grace, because the point that is made is that of the difference between confirmation and determination. And when you confirm, what is your duty?
That's right.
When you confirm, what is the duty of confirmation?
The minister did not have a right to introspect, determine, or look at aspects of whether the judge, or look at aspects of whether the minister had made his case or not, because this task was simply to confirm in terms of the Reconstruction Act.
So, Dr. Shumba, thank you for summarizing. Maybe to Mike, confirmation means something else. Does confirmation mean what Dr. Shumba said?
I think in terms of everything, because it's like I said, it's a learning day. I've learned a lot today.
I'm just saying, when you confirm something,
you're confirming. Confirmation is acknowledgement of something that you did not know, or it is given. You can say to yourself, I've learned something, and then you are confirming that you've learned something. So you can articulate
have
it
you
back
ever
that you're
signed a confirmatory affidavit to confirm something?
Yes, I have many. Yes.
So what is your
That is
duty
by right.
when I bring an affidavit, I sign and then you confirm?
Yes, that is everything that is
What
there
I
is
say.
true.
That's right.
Everything that you've said is true. So that's
So,
confirmation.
so what is the duty of a
Acknowledgement.
judge whose role is reserved
So,
confirmation?
thank you very much, Mike. I have to leave you.
Dr. Shumba, many thanks for the enlightenment. But I think this war is yours, Dr. Shumba. Is he still
Then
there?
you are not ready to sing Amazing Grace.
Yeah.
No, but what we have to say to ourselves, Dr. Shumba, before you go, Dr.
Yes.
Shumba, is to say to ourselves, besides, I know you're a political man and you know you've got a political party, and I love your drive for a better Zimbabwe. But besides that, besides the politics side, you have articulated this because you understand it best. You have articulated this, and then you're saying we don't want this to happen in your name, in our name. You are the person who is supposed to take this forward, whether you are sitting in parliament or not, because you said there's a next stage that this can be challenged, which is the Supreme Court. So it needs to get there so that we exhaust all the processes given in Zimbabwe to say, look, we tried. Dr. Shumba tried. Yes, you have traveled your journeys back in Zimbabwe through parliament. Yes, you were chased away from parliament because of your standing and your moral ground, but let's finish this story by taking it further, because you understand it better than anyone else.
I agree with you, and I have taken it. First, I want to explain to you that the minister can take this matter to the Supreme Court on appeal, and its outcome is predictable because it's in the act, unless the act itself is challenged by the discovery of additional documents from the respondents. However, this matter I have taken to the Constitutional Court before. I have discussed this matter, and I've stated that this matter is at the center of the capture of Zimbabwe. I took it to the Constitutional Court on appeal. It was also documents and the focus of my electoral appeal in the Constitutional Court. If you recall, I was there and appeared for myself. I also took this matter when we were invited to Poland, the circus that I refused to participate. And I stated it directly to President Mnangagwa that he is in violation of the Constitution by his continued negation of his constitutional duty to scrap this illegal act. So I have taken it to the president officially in the presence of many people. Other witnesses who were there include Maduku, Kosana Moyo, No Manyika, and others. And we walked away from the circus because we said we're not going to be part of this compromised process. As of now, what has transpired now will require the current litigants to walk this smile to the end. But once that process is exhausted, we are able to pick up issues and highlight what ought to be done in the next phase, which I don't want to preempt at this stage, at the constitutional level. Of particular interest, I would also cite the Parliament of Zimbabwe for failure to adhere to constitutional tenets and allowing an illegal or unconstitutional act to sail through Parliament, as well as highlight the constitutional violations to the Constitutional Court. But you see, the net effect is the captured process not going to repeat itself? Yes, but we'll still put the fight to the Constitutional Court, irregardless of any shameful outcome that may come out. Gentlemen, I suppose you have to allow me. I'm somewhere in the Indian Ocean. You've got to allow me to it's about midnight now, to try and pray and then rest and
that's right. So I think thank you very much
on another chapter.
Thank you very much.
Thank you very much, Mr. Mawela. Thank you, Mike.
Yeah, and thank you, Mike. And the debate must continue. And Mike, the idea of confirmation and determination. Mike, can you hear me?
Oh, no.
Mike, can you hear me? Can you hear me? Mike, thank you very much.